There was a huge ruling just coming down from the Supreme Court, and this is one that we have been waiting on as far as the fate of President Trump's trade agenda and whether or not, well, how the Supreme Court viewed the tariffs, the emergency tariff ruling. Well, the word we just got from the Supreme Court is the Supreme Court is going against the White House in this case and ruling that President Trump's authority to impose global tariffs was unlawful. I want to get to Katie Barlow. She obviously has been following this very closely as our chief legal correspondent and is at the Supreme Court. Joining us with more, we do not have Katie. All right. Well, we will come back to you with Katie and more on what this ruling means. But what we're also doing is keeping a very close eye on the markets right now and how much they may or may not be moving because of this, because there was a lot of questions as to how this would impact the global economy. Obviously, you have the impact on the White House right now, and if the president unilaterally could.
Hey, friends, Dr. John here. So what is happening right now? Two branches of government have arrived at the same conclusion through entirely different mechanisms and at the exact same moment. The Supreme Court is stripping away the tools Trump was counting on to govern. Congress is formally threatening to cut short the time he has left to use whatever tools remain. These aren't parallel stories. They're feeding each other, amplifying each other, creating a pressure system that no rally, no Truth Social post, and no media deflection can dissipate.
Announce tariffs, and the Supreme Court with this morning's ruling is essentially saying that no, he cannot. But the bigger question is, how does this impact you and me? How does this impact everyday Americans? And one of the measures for that, of course, is the stock market. And we had earlier gains of 200 on the Dow, and we're going to check in. Can we check now to see where the markets are and whether or not we've had an impact on this? I think we have the big board ready to go, so we could get an idea as to whether or not we're seeing a negative impact from this ruling from the Supreme Court. This is one of two rulings that we are keeping an eye on that we may or may not have received today from the Supreme Court, but two big ones. The other one, of course, deals with the jurisdictions of voters and voting maps. That might be pushed back a little bit. There was some concern as to whether or not if that came out too close to the midterms, it might have a negative impact on elections. I guess we could phrase it that way. But the word is that apparently.
This isn't slow erosion. This is a live, documented, televised implosion of the governing model that was supposed to carry this presidency to the finish line. Let me draw you a map of the battlefield, because understanding the geography of this squeeze is essential to grasping why it is so uniquely dangerous for this White House. From the judicial direction, the Supreme Court has issued a ruling that lands like a constitutional wrecking ball. The vote was 6-3. The majority opinion, authored by the Chief Justice himself,
might be pushed back a little bit more into the summertime. So this is the big ruling coming down today when it comes to tariffs. There we go. Thank you for putting up the markets right now. If you look at that green line, you can see a sharp up and a sharp down. The sharp up was before this announcement was made, when we jumped up to about 200 points, and the sharp down was immediately after this announcement was made from the Supreme Court. So we're going to keep an eye on things right now. It still looks pretty manageable. We'll say that, as we're now the markets are pretty much where they were at 9:30 before the ruling came down. Okay, what does the ruling mean? What does it mean to you and me? What is everything that all the analysts in the world now are going to be keeping an eye on based on what the Supreme Court just announced? So for that, we bring in Katie Barlow, our chief legal correspondent, to break down more as to what this means for you and me. Katie?
Declared that the president's sweeping emergency tariff authority was unconstitutional. The court said, in language that leaves precisely zero room for creative reinterpretation, that the president cannot treat emergency statutes and trade laws as a blank check to be filled in with whatever amount of economic coercion he desires. This was not a narrow procedural punt. This was the court taking one of the signature governing weapons out of the president's arsenal and snapping it in half on live television.
Hi, good morning. We literally, as you saw, just got the decision about 7 minutes ago, so I certainly have not read it, and it appears to be, let's see, it appears to be 170 pages long. The decision is 6-3, and the court is basically saying that the law that President Trump claims that he has authority to impose these tariffs is called IEPA, the International Emergency Economic Powers Act. And Trump says it's an emergency that we have these global trade deficits. It's an emergency that fentanyl is flowing across our borders from Canada and Mexico. I need to impose tariffs globally in order to combat these emergencies. That gives him the power to regulate importation during an emergency. And so the question is, does that also include the power to tariff and tariff kind of in an unlimited way. And what the Supreme Court here says is no, for two reasons. One, the language in the statute is vague, and it invokes something called the Major Questions Doctrine, which is when Congress gives up some of its power,
legally speaking. And the composition of that 6-vote majority is the detail that transforms this from a legal setback into a political catastrophe. Two of the justices who voted to constrain his power were his own appointees, the very jurists whose confirmations were supposed to guarantee a compliant bench.
And here, because tariff is like a tax, and that's a core congressional power, you've heard Congress has the power of the purse. Because that is a core congressional power, Congress has to be super duper clear when they're handing over some of that power to the president. And they're saying it's just not super clear on its face that the words regulate importation mean that the president can impose these global sweeping tariffs. So invoking what's called the Major Questions Doctrine, the court says that he does not have the authority under this emergency economic powers law to impose these tariffs. They vacate and they order the lower court to dismiss the challenge. This is a resounding loss for the Trump administration. It does appear to be 6-3 with Justices Kavanaugh, Thomas, and Alito in dissent. Again, I haven't read the bulk of the case, and it appears that some of the reasoning is a little bit fractured. But we get a decision here that is, in fact, a resounding loss for the Trump administration that makes it impossible for him to impose these tariffs in the way that he has been thus far. And it is a clear rebuke from the court of one of the president's many attempts to kind of assert control and power in a way that hasn't been tested before from the executive.
Looked at the text of the law and the structure of the Constitution and said, no. The power you claim does not exist. That is the judicial branch, including the members he personally placed there, telling him that the constitutional box around his presidency is real, it is locked, and they are holding the only key. Now pivot to the legislative direction, because the assault from Capitol Hill is arriving with equal force and far more personal venom. More than 70 Democrats in the House of Representatives have publicly, formally, and with their names attached to the official record, called for his removal from office. This is not a whisper campaign. This is not a background quote to a friendly reporter. This is a documented constitutional demand. The trigger for this escalation was the now infamous post about a civilization facing annihilation by nightfall, a threat delivered with a specific deadline attached, language that international legal experts immediately flagged as potentially constituting a grave breach of the laws of armed conflict. New articles of impeachment have been formally filed, accusing the president of usurping the war powers that the Constitution assigns exclusively to Congress and committing actions that meet the legal definition of war crimes. Simultaneously, demands invoking the 25th Amendment have been placed on the record by named senators and representatives, applying the specific constitutional language about the inability to discharge the duties of the office to the documented public conduct of the president. Emergency sessions have been demanded. The normal, glacial pace of institutional deliberation has been rejected in favor of calls for immediate, dramatic action. Two institutions, two branches, two separate constitutional languages, one identical conclusion. This presidency has crossed a threshold where both the judiciary and the legislature are simultaneously declaring that the power being exercised has exceeded the limits the framers established. And the combined effect of the court narrowing what he can do with the time he has and Congress threatening to shorten the time itself is what creates the image of a presidency that looks imposing on the surface, but is running a deficit in both tools and minutes simultaneously. Now let me be surgically precise about what the phrase court ruling cuts term actually means, because precision is the only antidote to the misinformation that swirls around moments like this. No ruling from any court, not even the Supreme Court of the United States, can alter the arithmetic of a presidential term. He was elected to serve a specific number of years, and the judiciary has no mechanism to change that calendar reality. What is being cut, and what the recent rulings are specifically and concretely eliminating, is the practical power, the toolkit. The specific levers and mechanisms that he was planning to pull to dominate trade negotiations, pressure foreign governments into submission, reshape the architecture of global commerce, and govern around the cumbersome obstacle of Congress through the liberal application of emergency declarations and expansive interpretations of statutory authority. The court has now ruled that this toolkit is constitutionally limited in ways the administration refused to accept and was entirely unprepared for. The Major Questions Doctrine, which requires clear and explicit congressional authorization before the executive branch can claim vast unilateral power over matters of enormous economic and political significance, has been applied directly to the heart of his economic agenda. And that doctrine does not stay confined to the tariff case. It travels. It applies to every domain where the administration has been operating under the assumption that a vague phrase in a decades-old law is sufficient permission to act like a legislature. Meanwhile, the congressional push for impeachment and the invocation of the 25th Amendment is the legislative branch making the corresponding argument on the military and fitness fronts. They are asserting that the war authority regarding Iran has been exercised far beyond any constitutional justification, and that the fitness questions raised by rhetoric threatening civilization-level annihilation are sufficiently grave to warrant the most severe constitutional remedy available. The term is being cut from both ends, not the calendar on the wall, the substance of what the office can actually achieve. And the convergence of those two squeezes, arriving from two different constitutional directions at the same moment, is what makes this period qualitatively distinct from every previous challenge this presidency has weathered. Let me lay out the specific sequence of events that produced this simultaneous two-direction vice grip, because the timeline is the skeleton upon which the entire narrative hangs. The president posted the civilization-level threat against Iran with a specific time-stamped deadline attached. The Supreme Court then ruled his emergency tariff authority unconstitutional in a 6-3 decision, with his own appointees standing in the majority coalition. The United States Senate, in a remarkable display of institutional frustration, walked out of a classified briefing on Iran after receiving what they described as non-answers regarding the cost, the legal authority, and the endgame strategy of the ongoing military campaign. In the wake of that briefing and the escalating rhetoric, more than 70 Democrats in the House publicly called for his removal, naming specific constitutional mechanisms and providing specific quotable legal arguments on the official record. Articles of impeachment were formally filed with nearly 100 co-sponsors, detailing 13 separate counts of alleged constitutional and legal violations. A federal judge, in a separate but related emergency order, issued a finding that the pattern of governance being displayed exhibited a logic structurally similar to martial rule. Retired military officers, voices that usually remain carefully apolitical, began publicly questioning the strategic rationale for the campaign against Iran. And the national counterterrorism chief tendered his resignation, stating explicitly that Iran posed no imminent threat to the United States, and that the march toward conflict was driven by external political pressures rather than a genuine assessment of national security necessity. Every single one of those developments landed within a compressed political and legal window, each one feeding the credibility and the political salience of the next. They compounded. A pressure system was born that no single element could have created on its own, and that compounding dynamic is the master key to understanding why this moment is different. He has survived individual setbacks before. He has shrugged off isolated political attacks. What he has never faced is this specific alignment where judicial limits on his power, legislative demands for his removal, institutional pushback from the military and intelligence communities, and a restless electorate already delivering massive swings against his political brand are all converging at the same time, all pointing in the same constitutional direction, all landing in an environment where the voters who will decide the next midterm election are watching and translating every development into a decision at the ballot box. Let me walk you through the specific constitutional architecture of the impeachment push, because the argument being made by those demanding removal is more sophisticated and harder to dismiss than the typical partisan broadside. The Constitution is unambiguous on the matter of war. Article 1, Section 8 vests the power to declare war in the Congress of the United States, not the President. Congress. The War Powers Resolution, a statutory codification of that principle, requires the executive branch to notify Congress within 48 hours of committing armed forces to hostilities and strictly limits unauthorized military operations to a window of 60 days, followed by a 30-day withdrawal period. The military campaign against Iran has been ongoing without specific congressional authorization, pushing past those statutory guardrails. The president has publicly asserted the right to continue the conflict until he alone determines it should cease. That combination of factors, an unauthorized launch, an unauthorized continuation, and an explicit rejection of congressional authority to impose limits is precisely what the 13-count impeachment resolution filed by Representative Larson is charging as a criminal war of aggression. Furthermore, the civilization-level threat, a public and time-stamped announcement that an entire civilian population would face destruction if their government failed to comply with presidential demands within hours, has generated specific and detailed legal analysis from experts in international humanitarian law. They apply the provisions of the Geneva Conventions that characterize such language as potentially constituting prohibited threats directed against civilian populations. The 25th Amendment demands from Senators Murphy and Markey and Representatives Khanna and DeGette are applying the inability to discharge the powers and duties of the office standard to a president whose public conduct, they argue, demonstrates a profound failure of judgment in the specific exercise of powers, nuclear command authority, military deployment decisions, foreign policy calibration, that demand the highest degree of constitutional and legal precision. These are not vague political insults. These are specific constitutional arguments grounded in specific, documented, and time-stamped conduct, and they are now the formal, mainstream position of a substantial block of the United States Congress, permanently affixed to the official record, with the names of elected members attached, available as a reference point for every future investigator, every future prosecutor, and every single campaign advertisement that will air in competitive districts. Now we must excavate the deeper layers of why this simultaneous squeeze from the court and Congress is more consequential than either pressure point operating in isolation. The convergence creates a political and constitutional dynamic that is fundamentally new. There is the dimension of effective power reduction, the specific and concrete ways the court rulings are limiting what can be accomplished with the time remaining, and why those limits compound across multiple policy areas simultaneously. There is the dimension of removal probability realism, the honest assessment of whether the votes for actual conviction and removal currently exist within the Republican-controlled chambers, and why the process of building the constitutional record matters immensely even when the immediate whip count falls short. There is the dimension of the institutional independence signal, what it communicates to the world and to the American electorate that his own appointees on the bench and members of his own political coalition are pushing back in ways that directly undermine the narrative of institutional capture upon which his political brand depends. There is the dimension of the tool replacement dilemma, why the administration cannot simply pivot to a different statute or a new legal theory to accomplish what the court has now declared off limits, and why the constitutional problem is baked into the approach itself rather than being tied to the specific statutory vehicle. There is the dimension of two-front amplification, how the judicial rebukes and the congressional removal demands feed each other's momentum, creating a combined political impact that far exceeds the sum of their individual parts. And finally, there is the dimension of the electoral trajectory, how this convergence is actively shaping the landscape for the midterm cycle that will determine control of Congress and define the final chapter of this administration. Let us take each of these dimensions in turn. Begin with the effective power reduction dimension. The tariff ruling did more than just invalidate a single policy. It eliminated one of the primary engines of economic coercion that this administration was counting on to pressure trading partners, leverage geopolitical adversaries, demonstrate dominance on the world stage, and signal that American economic might was being wielded with presidential force, unencumbered by congressional oversight. The tariff authority was never merely a tool of trade policy. It was a diplomatic weapon, the economic counterpart to military pressure, deployable in any confrontation where the threat of financial consequences was meant to alter the behavior of a foreign government without requiring a single vote in the House or Senate. With that tool now constitutionally constrained, the administration's capacity to threaten and deliver economic pain has been specifically and publicly diminished in ways that every foreign ministry on the planet can calculate with with precision. The Major Questions Doctrine, which formed the backbone of the court's reasoning, is not a one-hit wonder. It is a legal principle with legs. It requires clear congressional authorization for any claim of vast economic and political significance. That requirement now travels across every domain where this administration has been asserting broad, unilateral statutory authority without the requisite legislative permission slip, immigration emergency orders, domestic security declarations, foreign policy maneuvers, and the entire apparatus of executive emergency decrees that have substituted for the legislative process. Every single one of those actions now faces judicial scrutiny from a court that has already established, with the president's own appointees in the majority, that the blank check theory of emergency power is constitutionally invalid. The cutting is not abstract. It is the specific removal of specific instruments the administration was planning to deploy for the duration of its term. And the removal is constitutionally permanent. These tools do not regenerate when the news cycle refreshes. They require affirmative congressional action to be restored. And securing meaningful legislative action on anything of significance remains the singular governing challenge this administration has proven most consistently incapable of overcoming. Let us be rigorously honest about the removal probability reality. Credibility demands that we state clearly what the numbers actually say, rather than inflating the immediate threat in ways that ultimately undermine the genuine significance of everything else that is occurring. The impeachment articles exist. They are formally filed with specific charges enumerated. The 25th Amendment demands are on the official congressional record with the names of sitting members attached. Nearly 100 co-sponsors have signed on to the 13-count resolution. More than 70 named members of the House have publicly called for removal through one constitutional mechanism or another. These are established facts, and their political weight is undeniable. And the political reality that sits beside those facts is equally real and equally important to articulate. Republicans control the House of Representatives. Republicans hold sufficient seats in the Senate to block the two-thirds supermajority that conviction requires. The current political dynamics, however volatile and however charged, do not produce the necessary vote count for actual removal under the constitutional mechanisms currently being invoked. That is the honest, sober assessment. But stating that truth does not diminish the importance of the process itself. The significance of the removal push does not hinge exclusively on whether it results in immediate ejection from office. It creates a permanent, specific, and constitutionally grounded record that every future accountability effort will build upon. It forces every single Republican member of Congress to make a documented public choice between defending conduct that is increasingly difficult to defend and acknowledging constitutional problems that are awkward to admit. Neither option is politically comfortable in a competitive district where suburban voters are already signaling their discontent. It sustains the conversation about accountability at maximum volume, while every other institutional pressure, judicial, military, diplomatic, is simultaneously bearing down from every other direction, and it establishes the political predicate for future action if and when the congressional math shifts, as midterm elections have a habit of making it shift. The process is the accountability, and the members who are pushing the hardest understand that dynamic with absolute clarity. Now consider the institutional independence signal. This is the aspect of the convergence that cuts most deeply against the brand identity that has protected this presidency through every previous crisis. The political persona has been constructed in significant measure on the claim that the president's strategic investments in Supreme Court appointments, in cultivating congressional loyalty, in staffing the executive branch with loyalists, have rendered him effectively impervious to the institutional constraints that are supposed to check presidential power. The Supreme Court is his court. Congress is his Congress. The claim of institutional capture is the bedrock of the strongman mystique. The suggestion, repeated endlessly in rallies and on social media, is that every mechanism designed to restrain executive overreach has been realigned with his interests and will function as a protective shield rather than a check. The court's 6-3 ruling and the congressional push for removal simultaneously explode that claim in the most public, most documented, and most irreversible manner possible. His own justices applied conservative legal principles, the very principles he claimed to champion when nominating them. And those principles led them to constrain his power in a domain where he asserted unlimited authority. Members of his own political coalition walked out of a classified briefing rather than continue to absorb what they viewed as evasions and non-answers about a conflict he initiated without their formal consent. Voices from within the conservative ecosystem have publicly described his Iran rhetoric using terms like unhinged. The institutions he claimed to have captured are demonstrating in real time and on the public record that they possess their own internal logics, their own institutional imperatives, and their own constitutional obligations that supersede the personal loyalty he expected and the protection he assumed was guaranteed. That demonstration, visible to global markets, to foreign capitals, to every political operative calculating electoral positioning, and to every voter forming an opinion, fundamentally alters the political calculus. It contradicts the core narrative upon which the entire political operation rests. Let us address the tool replacement problem directly. This is the practical, mechanical consequence of the court's ruling that will frustrate the administration's attempts to simply pivot to a new approach. When a major governing instrument is taken away by a constitutional ruling, the options for response are limited, and each is fraught with difficulty. The first option is to locate an alternative legal mechanism, a different statute, to accomplish the same policy objective. But this approach runs headlong into the Major Questions Doctrine. The constitutional defect identified by the court is not tied to the specific words of the International Emergency Economic Powers Act. The defect is the underlying theory that a president can claim vast unilateral authority over matters of enormous economic and political significance without clear, explicit congressional authorization. Any alternative statute the administration might attempt to repurpose for the same goal carries the identical constitutional vulnerability because the theory that would make the alternative work is the exact same theory the court has now declared constitutionally insufficient. The second option is to work with Congress to obtain the explicit statutory authorization that the court has said is required. This path demands the one skill set this administration has most conspicuously failed to demonstrate: building legislative coalitions, engaging the institutional processes of actual lawmaking, and making the compromises and concessions that are the currency of Capitol Hill. The entire governing strategy was architected specifically to avoid that process, to use executive authority and emergency declarations as a workaround. Asking this White House to suddenly become a master of legislative negotiation is like asking a fish to climb a tree. The third option is to simply abandon the policy objective, which amounts to a public admission that the judicially constrained presidency cannot deliver what the unconstrained version was promising. Every available path forward carries political costs that this administration is uniquely ill-equipped to absorb. The steady accumulation of tools removed by the courts, with congressional authorization as the only viable path to restoration, is the mechanism by which the effective power of the presidency is being progressively diminished. The two-front amplification dimension is where the convergence achieves its most potent political effect. The court's rulings and the congressional removal demands do not simply exist as parallel independent developments. They are interconnected. They feed each other in ways that make the combined political impact significantly greater than what either could generate in isolation. The court's ruling weakens the administration's governing capacity and its international credibility. It signals to foreign governments, to domestic political actors, and to financial markets that the president's toolkit is constitutionally limited in ways the administration was publicly insisting it was not. That demonstrated weakness makes the congressional removal demands more politically credible. A president whose governing instruments keep being ruled unconstitutional by his own hand-picked justices is a president whose remaining power is visibly contracting even before any formal vote on removal is taken. And conversely, the congressional removal demands intensify the political damage inflicted by the court rulings. They establish an accountability framework that transforms each judicial rebuke from an isolated legal setback into another confirmed data point in a documented pattern of constitutional overreach. Congress is formally stating that this pattern warrants the most serious constitutional response the system possesses. The courts say the tools are constitutionally invalid. Congress says the conduct associated with those tools justifies removal. The combination of both institutional voices making the same judgment, documented, named, permanent, and simultaneous, creates a pressure system unlike anything this presidency has previously encountered. It is not equipped to manage this through the familiar instruments of narrative deflection and social media combat that have shielded it through every prior challenge. And then there is the electoral trajectory dimension. The convergence of these pressures is actively sculpting the political environment into which every candidate will walk as the next midterm election approaches. The accumulated weight of judicial rebukes, formal congressional removal demands, public criticism from retired military professionals, and high-profile resignations from national security officials is bearing down on Republican members of Congress who must soon defend their association with an administration that has generated all of these institutional responses within a single, compressed window of time. The impeachment alert is the loudest and most constitutionally explicit expression of that accumulated weight. The Supreme Court ruling is the most judicially authoritative expression of that same weight. Together, compounding, amplifying each other, making each other appear more credible and more politically urgent, they are constructing the electoral terrain upon which every competitive House and Senate race will be contested. A presidency that projects an image of strength but is demonstrably running out of both effective tools and political time, with courts limiting the former through constitutional rulings and Congress threatening the latter through formal removal proceedings, is a presidency whose political allies must make increasingly difficult calculations. They must determine whether continued, unflinching association is an asset to be leveraged or a liability to be managed in the specific districts and states where control of the next Congress will be decided. That calculation is being made right now in district offices, in campaign strategy sessions, in private conversations between Republican members and their most trusted political advisors. It is being made across every competitive suburban district and every battleground state. And the answer that an increasing number of those private conversations are producing is the answer that makes the impeachment alert real, not as a prediction of immediate removal, but as the constitutional and political reckoning that this entire trajectory has been building toward from the beginning. Here is the distilled essence of this moment. The Supreme Court has stripped away a signature governing power, ruling 6-3 that the president's emergency tariff authority was unconstitutional, with 2 of his own appointees standing in the majority and applying the Major Questions Doctrine that will now constrain executive action across every policy domain. Simultaneously, Congress has erupted in formal demands for removal, with more than 70 members publicly calling for impeachment or the invocation of the 25th Amendment, articles of impeachment filed with nearly 100 co-sponsors, and a permanent constitutional record being constructed that will shape every future accountability effort. The convergence of these two pressures, judicial and legislative, creates a combined force that neither branch could generate alone. The court limits what he can do. Congress threatens how long he can do it. The institutions he claimed to have captured are demonstrating their independence in the most public and damaging fashion possible. The political environment heading toward the midterm elections is being shaped in real time by the accumulated weight of these developments. A presidency that looks formidable from a distance is, upon closer inspection, being squeezed from multiple constitutional directions simultaneously. The courts are not being arrested. They are doing the arresting. They are removing the legal foundation from under the most ambitious claims of executive power. And the president, watching his toolkit shrink and his time horizon cloud, cannot stand it. The meltdown is not a metaphor. It is a live, ongoing, documented reality. The only remaining question is how much further the pressure can build before something fundamental gives way.